Welcome everybody. It's fabulous to see so many of you joining us today. I'm Linky Trott. I head up the employment team at Edwin Co. And our topic for today is to look at potential issues arising with HMRC and its investigations in relation to wrongful furlough payments and bounce back loans. It's also to introduce you to the cross-departmental team that we have put together to help clients who may be contacted by HMRC undertaking an audit of some sort on furlough payments and in relation to bounce back loans. I'm here today as well as Sean Bannister, who heads up our tax team, and Alex Beatty, who heads up our restructuring and insolvency team. I'm going to set out some of the issues arising in relation to furlough and how we can help. But I think the central message that we want you to take with you today, particularly from Sean, is that the earlier we are instructed, the more that we can help. We can look at the issues arising on a legally privileged basis, and then we can help frame that discussion with HMRC. So rather than trying to deal with HMRC and not getting the answers that you want and coming to see us, we would rather if you came to see us the moment you are contacted by HMRC. And indeed, what we are recommending to clients is that they undertake an audit of their furlough payments and in relation to bounce back loans. We can provide assistance with that in audit, and if there are any issues that you're worried about, we can have a look at it, tell you whether or not they are issues, whether or not there should be some sort of voluntary disclosure to HMRC, and Sean's team in particular has great expertise in battles with HMRC and representing clients. So I'm going to start off really with a quick summary of some of the background, which I suspect feels like a distant memory now. But really just to sort of take you through how quickly things moved in March of last year. And you'll all remember the various announcements that came out pretty quickly, one after the other. It all sort of started on about the 16th of, well, on the 16th of March, when the government announced closures of, for instance, poor old AXM nightclub. They had to close. And that was very quickly followed on the 20th of March. Hannah, if we could have the next slide, thank you. When Rishi Sunak announced the coronavirus job retention scheme, and there were more closures in relation to cafes, pubs, restaurants, all of whom had to shut that evening. I've described those as partial closures. Obviously, for the businesses involved, that's not how it felt. But that was pretty swiftly followed by the 23rd of March announcement that evening of the complete first lockdown that we had. Essential retail had to close, employees were directed to work from home, save where it was absolutely necessary and where that work could not be done from home. So we ended up in a situation where a lot of employers were sort of presented with a pretty frantic scramble to know what to do with staff. Obviously, pubs, restaurants, non-essential retail, that sort of thing, a lot of them just said to their staff, go home on furlough. And a lot of people were sent home. But the first government guidance on furlough was issued on the 24th of March, so on the Tuesday. I think the 23rd was a Monday evening at the announcement, and then first guidance was issued on the 24th of March. And there have been numerous amendments since. I've sort of set out there the 4th of April and the 9th of April because those are the amendments that were issued prior to the Treasury direction, which was eventually issued on the 15th of April, which I think is the next slide. Thank you, Hannah. So the Treasury direction is effectively what made furlough legal, what put it into law. It implemented the scheme. And the government guidance was changed again on the 15th of April, and there have been numerous updates since. I've set out there the updates to the Treasury direction, but the government guidance on its gov.uk website, which we all became so familiar with about the sort of rules and regulations relating to furlough and working, there have been 33 updates since the initial update on the initial issue on the 24th of March. So we ended up in a position where there was, at least initially, things became clearer as the government issued its various iterations of the guidance, but there's no doubt that initially there was quite a bit of confusion. And I just wanted to highlight one area of confusion which initially happened, was that the government guidance on the 24th of March stated that in relation to furlough grants and claiming grants from the government for furloughed workers, you needed to designate affected employees as furloughed workers, notify your employees of this change, and then a sort of rather generic statement saying, oh, well, it all complies with existing employment law requirements and it could be subject to negotiations. But of course, if you've got a restaurant or a cafe that's shut, not a great deal of negotiation, there's no work to do, and you send your employees home on furlough. But on the 15th of April, the Treasury direction, when that came out, this said an employee, furlough grants can be claimed where an employee has been instructed by the employer to cease all work in relation to their employment, if the employer and the employee have agreed in writing, which can be in electronic form, that the employee will cease all work in relation to their employment. And this is the first time there was a suggestion of a requirement for some sort of agreement between the employer and the employee, and that it needed to be recorded in writing, and that it needed to provide for ceasing all work. And that creates a tension between the guidance that had previously been issued and then the Treasury direction that came out on the 15th of April. And it may well be that HMRC are going to challenge furlough payments that were made without an agreement, and then prior to the 15th of April, and when employees were just sent home because the bar or the restaurant had shut. And in our view, I think that is an important distinction to highlight when making those representations to HMRC in the event that they do indeed make any challenge in relation to furlough grants that were paid over that period. And the same issue arises in relation to directors, for example. The government guidance initially stated that directors could furlough themselves, and said where furlough directors need to carry out particular duties to fulfill the statutory obligations they owe to their company, they may do so, provided that they do no more than would be judged reasonably necessary for the purposes such as they should not do work of a kind that would carry out in normal circumstances to generate commercial revenue or provide services on behalf of their company. So that was the guidance, and it felt quite broad. As long as you weren't sort of effectively running the business, but you were just sort of dealing with all your sort of compliance stuff and usual director's duties, that was okay. But the Treasury direction that then came out on the 15th of April stated work undertaken by a director of a company to fulfill a duty or other obligation arising by or under an Act of Parliament relating to the filing of company accounts or the provision of other information relating to the administration of the director's company. And we can see there that there is a bit of that seems to be a much narrower definition and much narrower interpretation of what work a director could do whilst they were being furloughed. And again, there is similar tension there, and we would say if there's any criticism of work undertaken by a director, they should really be directed to the guidance that was issued at the time. And the apparent tension between that guidance when they furloughed themselves and did that work and the Treasury direction that came out later. And there are lots of these examples over the period of time in relation to the different iterations of the Treasury directions and the different guidance that was issued. And what you need to know is, well, if you're being criticised for making a furlough payment, or you have a client who's being criticised for making a furlough payment by HMRC, and they say it was wrongly paid, what we would say is, well, you need to look at the guidance at the time. And do clients have that guidance at the time? Probably not. We do. We've got all the different iterations of the guidance, all the different iterations of the Treasury directions, and we can help frame those discussions and those representations to HMRC. So why does it all matter? Well, it's all about the portal being opened with extreme urgency on the 20th of April. Credit where credit is due. The government did say, we are going to get this cash to businesses as quickly as possible. Portal opened on the 20th of April, and indeed payments were made within about a week. They really did get the cash to the business. But with that comes a sting in the tail, and that is all businesses were instructed to keep all records for a 5-year period. And HMRC will, over the next 5 years, be undertaking audits of furlough payments, and where they believe that there is some error in relation to that furlough payment, they will be seeking repayment, possibly interest and penalties and costs. They also set up a whistleblower hotline for employees to report any incorrect furlough claims. And the National Audit Office has already reported that there 10,000 reports have been made to that whistleblower hotline. And we know from recent press reports that HMRC have started those audits. They're probably going for the low-hanging fruit, and they're starting with those registered with the whistleblowing hotline. But they've started those audits, and they are looking at email records, phone records, web browsing history, presumably all with an idea of trying to establish whether or not somebody has been working and what sort of work they've been undertaking, and whether or not it was a genuine furlough grant payment. And certainly anecdotally, I have heard, I've got a lot of young adults in my life who are at uni and they were working in bars and restaurants. Of course, that all sort of stopped in the middle of March. And there is anecdotal evidence that I think we've probably all heard that a number of businesses continued claiming furlough, although they had already dismissed those staff that they claimed furlough for. So employers over the next 5 years may well be contacted by HMRC undertaking an audit of their furlough payments. We would say do that audit now, because if there is an issue and you identify it, as Sean will explain to us, you will get brownie points from HMRC for being a sort of voluntary disclosure rather than one that's had to be weeded out by some audit process. And I think we see that there's a full range of sort of culpability, all of which we can help with as part of this cross-departmental team. I mean, there is, for instance, initially just the failure to, understand the need for an agreement with the employees not to undertake work during furlough and for it to be recorded in writing, which I touched on earlier. There's that overstepping of the mark in relation to directors' duties, and it's important to refer back to the guidance that was issued at the time. What was your knowledge at the time that those furlough grants were applied for? I think there are also going to be issues arising for the miscalculation of furlough grants. Certainly when partial furlough was introduced around May or June, the months roll into one, they were fiendishly difficult calculations. I know we've got a number of accountants here with us today, and no doubt some clients will have asked you to help with those calculations, because where you've got a sort of irregular hours worker who does a lot of overtime, working out partial furlough payments for them was extremely complicated. And it may well be that there are just errors and genuine mistakes that have been made. And then I think we sort of move into the sort of slightly more difficult arena where Sean and Ali's team can particularly help in relation to the deliberate overinflation of claims. And it may well be that it was for a very genuine fear of wanting to keep the cash coming into the business, having a real anxiety about, you've got rent that's coming up and needs to be paid. And you just, the director just made the wrong decision and thought, well, look, I won't take those individuals off the furlough list, although actually I have already terminated their employment. And we can help frame those sort of discussions with HMRC. And then right at the other end of the scale, you've got the real fraudulent stuff, which is serious for directors and their personal liabilities, which Ali has experience with. And that is, I've heard anecdotally that businesses in a similar sort of business swapped staff, because it was permissible for you to continue working whilst you were furloughed for another business. So if your bar or restaurant shut and you were on furlough, you could go and work at Tesco's and still receive your furlough payments, your salary, and your previous employer claiming your furlough grant, but you're working with Tesco's. That was perfectly legitimate. And what I have heard anecdotally is that some businesses swapped workforces. So they were effectively all still working. They were just sort of working for a different employer, and both employers were claiming the furlough grant. And of course, that is on the much more fraudulent end of the scale, where you will need specialist help and specialist representation. So how can we help? Well, I think we've called it the Edwin Co. Advisory Task Force on Furlough Challenges. It's a cross-departmental group, and I'm going to hand you over to Sean in a moment, who has great experience in dealing with HMRC and making representations to HMRC. And then Sean will hand over to Ali. Over to you, Sean.
Thank you, Linky. Hannah, can we move on to the first slide, please? So I think it's worth pointing out from the start that HMRC do accept that there are going to be some errors in furlough claims, and corrective action can be taken, and it's expected. Corrective action can take place via the next claim and the next return, effectively, and you can adjust the amount of furlough payment being requested in that claim with reference to any amount overclaimed in the prior period. Or if you're in a situation where your final claim has been submitted and then you've noticed an inaccuracy, you can make an application to HMRC to repay that amount within 30 days of that happening. And I think the continuing change in guidance, the continuing change in guidance that Linky's been discussing, it is completely envisaged that there will be some issues around furlough payments. And HMRC have said that when they are looking at enforcement action, they're not looking to target innocent errors. But there will be circumstances where corrective action is required. That corrective action is going to happen after the 30-day window has elapsed and outside of the claim period. And again, HMRC envisages this happening. You will have a 90-day window to report both accidental and deliberate overpayments of furlough. It's quite surprising that HMRC have included deliberate in that. You can see that there's a very real desire for the cash flow to be returned back to the Exchequer. And I'll come on to some of the mechanics around how that interacts with the Taxes Management Act in a moment. But it does allow for this correction within a 90-day period. The 90-day window starts on the date that the amount that was claimed has been received, or on the date when entitlement ceased. So if there was a change in an employee's circumstances after the claim had been made and received that resulted in that claim no longer being valid, the 90-day period would start at the later date. That 90-day window, whilst useful, and again, coming back to some of the points that Linky raised, it's all about trying to address issues early and also develop robust systems to make sure that if errors do arise, they're identified more swiftly in order to mitigate penalty exposures. There is still this opportunity to do this within this 90-day timeframe. That said, a 90-day timeframe is quite a short period in which to recognize these issues. I suspect we're going to see a number of issues identified post the end of the tax year, and perhaps when firms are looking at their overall PAYE exposures in May, June, as part of P11D exercises and P60 exercises, etc. So I think there's going to be a bit of a pinch point there, and I'm expecting that to happen. So we have a 90-day window. We can make those changes within that 90-day window. Of course, if issues come around, our issues are identified after the 90-day window has elapsed, we can then go to HMRC, and we are required indeed to go to HMRC and make a notification that an issue has arisen and it needs to be rectified. So Hannah, can we just move on to the next slide? Once that it's been identified, an obligation to report this as soon as possible to HMRC arises, as well as a requirement to repay those funds. The way this is dealt with from a technical perspective is that the amount overclaimed after that 90-day period has elapsed will be treated as an amount of income tax. Why is that important? That means it falls within the general regime under the Taxes Management Act and some specific provisions relating to Finance Act 2020 that apply to direct taxes, with the Finance Act 2020 points applying specifically to the furlough amount. That allows us to understand what HMRC's powers are, and also, perhaps more importantly, what taxpayers' protections are afforded by the Taxes Management Act, and how we're going to define the dispute going forward. Just on a technical issue, interest accrues from the date the amount was received or the date that the entitlement to that payment ceased. So again, from a calculative perspective, you're looking at this as a taxpayer, or alternatively as an accountant, you'll be looking at that from a timing perspective. It is not necessarily the case that where a claim has been made in good faith and subsequently found to have been made incorrectly, that a penalty will apply if a notification to HMRC is made after the closure of the 90-day window. But the taxpayer is now potentially required to demonstrate why a penalty is not due. This becomes incredibly important when we're notifying HMRC of an issue in relation to furlough, because this is our opportunity to frame the dispute going forward and how we're going to handle the disclosure. We need to take time to sit back and identify what the error was, why the error occurred, how that fits into the guidance that was published by HMRC at the time. Are there any other mitigating factors in the context of perhaps reasonable excuse that one would need to give some consideration to? Are there any other factors that one would need to consider? We then put that together and we build out an argument that we can present to HMRC when we're talking to them about the disclosure being made. What frequently happens in tax dispute matters is that when HMRC request information or when HMRC make an approach in relation to such a matter, there is a desire, and quite valid desire, to simply provide data to HMRC that they've requested without any additional narrative being provided. And whilst I'm a big fan of providing succinct answers to HMRC questions and the supporting data that's required, it's essential that only the right information is provided to HMRC at the time, and also the information to which they're entitled, so that any legal obligations are being met, as well as making sure that we aren't overly providing information that may lead to additional erroneous questions being raised by HMRC that create additional work for the taxpayer and further frustration to their ongoing business activities. So we have to sit back, understand what HMRC are requesting, understand what data we have available to us in order to answer that question, what data HMRC are entitled to in order to help support our answers to that question, and then how we want to frame the dispute going forward. Again, just to echo back, HMRC's published guidance has been pretty clear on where innocent errors arise. They aren't looking to charge penalties. That sits in somewhat conflict about the way that they have approached the penalty regime, which I'll come on to in a moment. But they aren't looking to punish innocent errors in this scenario. So again, I would always be taking the view that if HMRC have discretion about whether they're going to charge a penalty, that you seek to argue that it's an innocent error in the first instance, where indeed an innocent error has taken place. That's not going to always be the case. There are going to be circumstances where the error wasn't innocent. And again, we're going to have to work as taxpayers and as advisors to taxpayers to help navigate those particular issues. Hannah, could you move on to the next slide, please? So, for those that have experience of the penalty framework, again, this exists within the taxes management model for behaviour-related income tax offences, and any penalties are going to be dealt with as failure to notify penalties. That's a technical term, but basically what it's saying is you either fail to notify HMRC of your chargeability to tax by not submitting a return, not relevant in this case because we're dealing with returns submitted, or you deliberately omitted or you concealed an amount that's taxable. And again, the penalty matrix that HMRC have decided to apply and as a result of Finance Act 2020, so the government decided to apply, is to treat all penalty issues in relation to furlough as being deliberately and concealed acts by the taxpayer. So immediately, we're starting a much worse situation than a taxpayer who had submitted a careless return and had failed to include a number carelessly, made an omission by virtue of that, were being treated as if we'd made a deliberate act, and that deliberate act has been concealed in the format of the return. That means that our penalty loadings start at 100% as our maximum penalty, which is our standard penalty. If the quality of the disclosure is good and we make a prompted submission to HMRC in relation to the furlough failure, the minimum penalty we will be looking at is a 50% penalty. And if we make an unprompted disclosure to HMRC, the minimum penalty we'll be looking at is 30%. So the first thing to say is unprompted disclosure will significantly reduce the financial burden of these in these cases. So that's one thing that clients need to be aware of. And again, an early review in relation to the period that is, in relation to being a period where there has been conflicting guidance, issues will no doubt have arisen, will almost certainly result in reduced amounts of penalties being levied in situations where penalties are due to be levied. So I think that's important. It's one of those issues where one doesn't want to bury their head in the sand if they want to make the most savings possible. It's about taking early action and dealing with that swiftly. It's important to note that timing of disclosure will also help mitigate penalty loadings. So again, the timing and the quality of the disclosure will form part of that that penalty mitigation. So when we're looking at those bandings in relation to the taxes management standard model, we're looking at quality, and quality being the amount of openness and quality of disclosure you apply to HMRC, and also the timing with which you approach HMRC in order to make a voluntary or prompted disclosure to them in relation to that matter. It is going to be eminently better to approach HMRC rather than have HMRC approach you. The other thing to remember in tax disputes, as well as the penalty issue, and I'll come on to a couple of wider points around penalties in a moment, is that when we are approaching HMRC or being approached by HMRC, we're either in a proactive or a reactive phase. If we approach HMRC, we're in a proactive phase. If HMRC approach us, we're in a reactive phase. If HMRC's initial approach to us is a raft of 40 questions that they are legitimately entitled to ask, you are going to be dealing with a substantially more complex dispute than a situation where you have identified that there's an issue, you've made an unprompted disclosure, and you've been able to frame that disclosure appropriately. HMRC are entitled to go fishing as part of their work. So it's important to note that HMRC may use furlough investigations to also look at wider issues related to PAYE, etc. And again, dealing with matters in an unprompted fashion is going to undoubtedly result in better resolutions for clients and less costly tax disputes with HMRC in relation to professional costs and time incurred than a situation where they are being approached by HMRC in relation to the matter at point. And it's clear in relation to the way that the HMRC have enacted, well, the government have enacted the legislation that they wanted to treat furlough situations where there was a suspicion of furlough fraud as fraudulent in effect, because deliberate and concealed acts are fraudulent, and therefore looking to charge the highest level of penalties possible. So whilst HMRC have said publicly they aren't going to they won't look to charge penalties where there's an innocent error, I think that bar as to what constitutes an innocent error is going to be applied at a pretty high level for individuals. In relation to your standard defences, it will be worth giving some consideration to whether reasonable excuse applies in relation to penalties. Reasonable excuse is subject to quite a lot of conflicting guidance and case law, etc. But there may be some points where reasonable excuses in play, in particular where government advice was relied upon or specific HMRC advice was relied upon. There might be some interesting arguments around reasonable excuse and penalty loadings there. My initial reading is that penalty suspensions won't be available, but again, I think it's worth giving some consideration to. because HMRC should be treating these as deliberate and concealed acts, and penalty suspension is only available in situations where the taxpayer behaved carelessly. And as I've said previously, the standard penalty mitigation for quality of disclosure, etc. Hannah, could you move on to the next slide, please? And I just wanted to talk about the situation when HMRC opened the investigation rather than making a voluntary and unprompted disclosure. Before doing so, I rather carelessly failed to mention that the ultimate penalty sanction that HMRC have available to them is pursuing a criminal prosecution. Again, where the situation is abusive, there is a very material risk of criminal prosecution being in point, and taxpayers and those that advise them need to tread incredibly carefully around that, especially when we're looking to find a civil settlement for the taxpayer. And again, specialist advice is needed at the juncture when an approach is going to be made, particularly if it's identified that the claim was substantively abusive, and thought should be given to whether or not further protections are going to be required for the taxpayer in order to prevent there being a criminal charge against them. And there are options available to us under the contract disclosure facility regime that potentially will give us the protections that we require from a criminal prosecution in relation to such a matter. But again, we can come on to that if required. But if HMRC approach you, I think there's a few things that taxpayers should be thinking about and their advisors. I think step one is to take advice and not to respond to HMRC without having done so. There are certain situations where HMRC will request information that they aren't entitled to, information that, and also there are certain situations where you'll want to provide narrow and specific answers to certain questions in order to manage the dispute going forward, rather than long and rangy answers that may create more issues going forward. You also need to sit down and establish what timelines apply and diarise response deadlines. It's important to deal with HMRC continuously. Also, there are situations where fines can arise under Section 9A in relation to failure to respond to certain letters and failure to respond to certain information requests in Schedule 36. Similarly, so those matters need to be considered. The second step is to conduct an internal review of what took place and why it took place, mapping out what internal processes exist to mitigate such failures and why they failed, if indeed they did fail. This is something where there's going to be increasing amounts of work, I feel, for, in particular, larger businesses, but some small and medium-sized enterprises should also consider it, in order to put in place robust systems that not only seek to mitigate the risk of failures taking place, but also allow you to more readily identify where failures have happened, so that action can be taken within the 30-day or 90-day deadline to mitigate penalty exposures. And also, in the future, if there was an issue that wasn't identified or picked up, to be able to demonstrate to HMRC that the business took all reasonable care in relation to its actions, in relation to its processes, in order to mitigate the risk of these failures taking place. And I think HMRC would take that into account when considering how they're going to deal with the dispute going forward. Another point is to assess whether any data that is being requested is required to be provided. Establish whether HMRC is in time to open the inquiry. We are dealing with income tax issues. We're subject to the discovery provisions and standard inquiry deadlines. All those points will need to be drawn out, especially as time progresses. At the moment, not so relevant because we're dealing with live tax years, but assessing whether HMRC is able to open the inquiry is going to be increasingly important. And then also to prepare as fulsome a response as possible and frame your arguments at this stage. Whilst we're in a reactive mode, now is the time to get yourself on the front foot with HMRC's investigation. If you have identified issues that require resolution, then consider proposing a settlement structure in relation to those issues at this stage, rather than saying to HMRC, here's all the information, how do you see this settlement going? It's for us, we live in a self-assessment world, and it's for us to define how we wish this dispute to go forward. Step 3, As the dispute continues on, consider whether, if an assessment is issued, whether an appeal to the tribunal is required, and there is a matter of law point that needs to be explored in the first tier or upper tier tribunal, and/or whether review from HMRC's perspective is required. The general guidance is to always request review. HMRC will undertake an internal review of the case and how it's being handled, and whether the assessment that's been issued or the conduct of the inspector is in line with what's expected. Often, those reviews come back and simply say, yes, everything is as it should be. That is generally my experience advising in this area. But the tribunal, should the input of the tribunal be sought at a later date, will have expected you to requested review and will consider it as part of their findings as well. So I think as part of the process, review is something that's going to be required. And can we move on to the next slide, please? And just in summary, prevention remains better than cure. Have a robust system in place backed by advice, and obviously my colleague Linky can help with that and work with you to put in place robust systems. Early detection of issues will decrease and/or remove the risks of penalties. So I wouldn't wait until the standard year end in order to conduct a review. I would do it as soon as possible, and I would be actively doing it if you can do it at least within a quarterly time frame, so that one can identify issues as swiftly as possible. Unprompted disclosure will decrease penalty levels substantially and allow you as a taxpayer to better frame the dispute. You'll be in a proactive mode rather than a reactive mode. That's hugely attractive, and you're dealing with smaller numbers immediately because the unprompted disclosure will be looking at lower penalty loadings straight away. And if HMRC open an investigation into CJRS payments, do be aware of the risk of increased financial penalties and in particular criminal action. And therefore you need to make sure you know your rights. I will pass across to Ali momentarily. Ali I did mention at the start of my discussion that there were some tweaks in relation to how the Finance Act 2020 interacts with the Taxes Management Act. And Ali has some interesting points to raise in relation to company officer responsibilities and liabilities in that context. So I shall pass you over now. Ali.
Excellent. Afternoon, everybody. Thank you, Linky. Thank you, Sean. I'm really going to cover 3 points. I'm going to very briefly touch on furlough abuse, and then I'm going to go on to talk about bounce back in the context of director's duty, and thirdly, I'm going to go on to talk about the consequences of potential insolvency in COVID and what that impact has on director's duties. The first slide ought to be, Hannah, the slide to do with furlough abuse. Excellent. Right. Let me start by saying, because Linky and Sean have dealt with this quite extensively today, I'm really going to keep this very simple. It's going to be a bit of a smash and grab this. For those of you who are football fans, you might understand the analogy when I explain that for my sins, I am a sad but absolutely mad Crystal Palace fan. And for anybody who's aware of what happened last night, where forget about 2 shots, Crystal Palace only had 2 touches in the penalty box against Brighton, and yet still managed to score twice and still won 2-1. You'll understand what I mean, the context of smash and grab. So this is it. This is my smash and grab about furlough abuse. As I say, I don't want to repeat what Linky and Sean have said about this, but do want to make an important point about the consequences to the directors personally. I mean, to put it into context, we know, according to HMRC, there is something like 3.5 billion they say has been wrongfully paid away. Linky mentioned there's at least 10,000 investigations. I've seen it suggested that it's as high as 27,000 investigations. There have already been 2 successful criminal prosecutions of directors for abusing furlough, and there's at least 1 firm of accountants in South London who are being investigated by HMRC and the local fraud squad for creating fictitious employees for the purpose of benefiting from furlough. And as Sean touched on, so Schedule 16 of the new Finance Act, this is the provision that introduces personal liability for directors who have deliberately participated in furlough abuse. And again, Sean's explained all of that, you know, and we've all heard the stories. We all know about the companies that have put staff on furlough, but have asked them to continue working, or suggested that they volunteer to continue working, or have actually put staff on furlough, not actually told the staff. So those staff have continued working, not realising that 80% of their salary is being supplemented by these grants. And of course, the worst example we have are companies that have simply set up fictitious ghost employees for whom they are claiming for. In those sorts of scenarios, where HMRC becomes aware of this, Schedule 16 now entitles HMRC to serve a personal liability notice on both the company and the directors individually. And irrespective of whether the company pays or not, the director is also personally liable to repay HMRC. And it's very simple, as it says on the slide. It arises in two situations. It's where the director has knowingly, deliberately caused these payments, or well, received these grants, knowing that he's not entitled to them. Or secondly, where the director himself has been the beneficiary. So in other words, he's received a grant under furlough and then himself has received it for his own personal benefit. So those are the two circumstances. And as Sean mentioned, there's also criminal sanction there as well. Where this gets quite interesting though, is normally HMRC will have these powers to impose personal liabilities in circumstances where a company has actually gone into a formal insolvency process. So it's already in liquidation typically. What's very draconian about this is HMRC are entitled to serve the personal liability notice on the director individually where the company is in an actual insolvency process, or where HMRC believe that there is a serious possibility that the company may go into insolvency at a future date. So just pausing there, you know, for the accountants on this call, you'll understand what I mean about how severe that is, because, you know, to judge whether a company is potentially or likely to become insolvent is a very difficult question. You know, weighing up all the contingent liabilities, prospective liabilities, future liabilities that may or may not arise. You know, most accountants will struggle in deciding whether there's a serious risk of a company going into insolvency. Yet here we have a situation whereby a HMRC officer, who, let's be honest, is a civil servant based in Glasgow, based in Worthing, wherever, if in that officer's opinion, he thinks there's a serious possibility this company may go into insolvency at a future time, then he's entitled to serve, or HMRC is entitled to serve the personal liability notice. So this is pretty draconian stuff. And again, just to touch on what Linky and Sean have mentioned, for any accountants on this call, particularly you need to pay attention to the fact that if you become aware of any directors of companies who have been abusing furlough, there is a potential there for you to file a suspicious activity report. This is proceeds of the crime. It's potentially money laundering. So again, some pretty serious consequences that flow from this. So, as I say, smash and grab in terms of furlough. Next slide, please. Right, the remainder of my talk, I want to move on to something that's not been covered by Linky and Sean. So I want to talk about bounce back, and in particular, the consequences to directors of abusing bounce back, because I think this is going to become a huge issue over the next 12 to 24 months. And in particular, it's important to bear in mind that the powers to make claims and recoveries against directors are not limited to HMRC. This situation will arise where any company goes into insolvency, a liquidator has the power to claw back money from the directors if they think these bounce back loans have been abused. And just to recap, starting with the basics, I set out here on that slide, you'll be aware that under the Companies Act 2006, directors' duties are codified. So the main provisions are set out there. The two particular ones to be aware of, Section 172, the duty to promote the success of the company. Section 174, the duty to exercise reasonable skill, care and diligence. Next slide, please. Hannah, next slide, please. The test itself for any director is a pretty low threshold. It's a subjective test, right? So if you imagine a director's in the dock, he's before a judge. The judge is required to imagine, well, what does this particular director know? What is his level of knowledge, his expertise, his skill? I, as a judge, am obliged to judge this director based on what he knows and how he behaves, okay? So fairly low threshold, okay? However, there are a couple of instances where that's disapplied, and instead, the courts will apply a higher threshold, an objective test. And if you can go on to the next slide, please, Claire. Sorry, Hannah. So I said it out there, the objective test is what an intelligent and honest man in the position of the director would have done, believing whether it was for the benefit of the company. So effectively here, the judge is stepping into the shoes of the director and saying, well, if I was the director, what would I have done in these circumstances? And this is particularly important because when we come to considering whether the director properly applied bounce back loans, it's going to be an objective test. It is going to be the higher threshold of trying to work out, well, you know this is government money, therefore, what would an intelligent and honest man do in those circumstances? Next slide, please. And in particular, actually, can you, sorry, that's fine. And I'll come back to the relevance of this is that when we think about where we are at the moment, we have situations where directors are faced with making decisions about what they do with their companies. We know, for example, The Economist describes it as what's called a zombie economy. So we have lots of companies that are stagnating, but there's no pressure on them to actually go into an insolvency process. There are VAT holidays, there are rates holidays, rent holidays. Furlough looks like it's going to be extended another 6 months next week in the March budget. So for the time being, all of these companies are continuing to stagger on. But in the meantime, a lot of these companies, a lot of directors have received bounce back. What are they meant to do with this money? And if they have done with it, if they've already utilised these monies, how do they then justify it? Because the critical thing about bounce back is it's meant to preserve the business of the company. That's the critical thing. It's about holding the ring. It's about making sure that all those businesses that went into lockdown come out of it on the other side intact so they continue to trade. So in other words, what these monies are not meant to be used for is directors are not meant to decide, okay, well, whilst I'm in this zombie state, I will pay certain creditors who I need to keep sweet, so my critical trade suppliers, but I'll ignore other creditors, typically HMRC. That is an abuse of bounce back. Secondly, what bounce back is definitely not meant to be used for is remunerating the directors, in particular in the form of dividends. Again, think about what this is about. It's preserving the business. It's not about making sure the director still continues to earn a living because you're in the same boat as everybody else. So dividends, out of bounds, directors' loan accounts, out of bounds. And finally, what bounce back is definitely not meant to be used for is for the purpose of investing that money for business opportunities. I mean, I'm sure you've all heard the stories, but I mean, I've had approaches from directors or rather their accountants talking about or expressing concern about directors who have used this money, for example, to purchase supercars, Rolex watches, land in Turkey and Romania. The worst one I had was an accountant who tried to refer a director to me, and I use the word try. You'll understand why I turned this guy away when I was told that the director had used 25,000 of that money to pay off his drug dealer, and the remaining 25,000 on account for future drug supplies. Now, when you apply the objective test I've just mentioned about what you're meant to do with this bounce back money, I can't see how that's ever going to cross the threshold. So, really important that directors understand what this money is used for, and the accountants on this call, equally that you understand what it's meant to be used for. And in those circumstances where the directors have already applied that money, To the accountants on this call, what I would say to you is there's a lot of work here that needs to be done for the directors. It's not too late to document why they applied for that money and how they've applied it. So, for example, what I would expect to see if I'm defending a director who is accused of abusing bounce back, what I will be looking for is cash flow forecasts for the next 12 months, about trial balance sheet showing that this company is possibly still insolvent and can continue trading. I would want to see board minutes. I want to see resolutions, all the sort of bread and butter stuff that accountants can and do prepare for their clients. So again, I actually think there's an opportunity here for accountants. And that then leads on to my final slide, which I called up rather early, sorry. Hannah, go back. It's the one survivor in the Twilight Zone. That's it. Of course, the other dilemma that directors are going to face in over the next 3, 6, 12 months is, can they continue trading these companies when we eventually come out of lockdown? And the issue here is, if you go back to the director's duties in the Companies Act, effectively, the director has the duty to act in the best interest of the company, i.e. its shareholders. But what the law has says is, where the company is actually insolvent, whether it's balance sheet or cash flow, then the duty shifts. The duty shifts to acting in the best interests of the creditors. But that's all changed about 18 months ago when we had this decision called Sequana. And this is the one legal case I just quickly want to dwell on, because Sequana has shifted the goalposts. And this was a very typical situation. I mean, there were huge amounts of money involved, but a very typical situation of a company where the directors had participated in a tax avoidance scheme, or tax evasion scheme, as HMRC like to call it. HMRC had initiated an investigation. HMRC had notified the directors that they believed they had a substantial claim for outstanding tax, but the actual amount hadn't crystallized. It was going to be a substantial sum, but they had actually put a liquid value to it. The directors in the meantime had amassed a cash pile, and so they had this dilemma. Do they pay the money up to the shareholders, in this case the holding company, or do they hold the money back to wait and see if HMRC brings a claim? So you get it. It's that balancing exercise. Whose interest are you acting for? On paper, this company was solvent. They decided to pay the money to the shareholders. And what the court said was, that's a breach of your fiduciary duty. The reason being, because you knew that there was this contingent claim from HMRC. So even though at the time you paid the money away, the company was solvent on paper, if you took into consideration the potential claim of HMRC, it could possibly have become insolvent. So effectively, what the courts are now saying is, if you're a director or you're an accountant advising a director of a company, you need to take into consideration whether there is a likelihood that this company will become insolvent. Likelihood is defined as probable. So pause there, just think about that. Quite a shifting in the goalposts. We've gone from being insolvent to simply likelihood or probability of insolvency. And in that situation, the duty of the director is to act in the best interest of the creditors. So you think about where we are now, think about all these directors who have to make these decisions about, okay, we may be able to come out of lockdown and start trading in April, in May, but we've got all these accumulated liabilities, VAT, rate, rents. Some of them may be written off, some of them may not. We've also got bounce back. The critical point being it's a loan. They need to be repaid at some stage. Directors need to be very careful now about deciding whether they can continue trading. And this is where accountants are going to have to be even extra careful in giving the advice, doing those cash flow forecasts, drafting those balance sheets, trying to work out, is there a justification for continuing to work? And if all else fails and you're not in a position to do so, that's when we step in. That's when we're able to give that professional advice to help. That covers my section. I hope that's been of assistance. And as with Sean and with Linky, happy to take any questions from anybody. Thank you.
Thanks very much, Ali and Sean. I'm in charge of questions, and forgive me, I did forget to remind everyone to post questions as we went along, but thankfully some of you are way ahead of me and you have posted some questions. Ali, the first one that was raised is who polices bounce back loans, because they're not issued by HMRC and they don't have any power over the loan. So if the lender becomes insolvent, yes, sure, it's the insolvency service, but if they don't become insolvent, who, if anyone, polices that bounce back loan issue?
That's a good question. I think the situation that I'm describing is where the company actually goes into an insolvency process. So it will be the liquidator and possibly the insolvency service itself, because of course they have also additional powers to disqualify directors who they think have abused bounce back. If you have a company where you believe there has been abuse of bounce back, but actually for whatever reason there's no pressure to put this company into an insolvency process, the best advice I can give you is don't do it then. As long as the directors are not wrongfully trading and the losses are continuing to accumulate, then to answer the question, you may be better off trying to avoid an insolvency process, because in that scenario, you're absolutely right. There is nobody who can pursue the recovery of the bounce back. It's only a liquidator.
Thanks, Ali. That was from Anthony Batty, but Michael Hawkins also directs a question for you in relation to the comments that you make about the proper use of bounce back loans. Forgive me, it has just been overtaken. Also applies to all unincorporated businesses, is that correct?
Yes, it would apply to whether it's an LLP, whether it's a partnership, absolutely. And
Nigel Harrison, he's asked if a company has two directors with 50% share for the purposes of limited liability, are they shareholders or directors? I think the answer is they're both, aren't they? But for limited liability purposes.
Sorry, Linky, what's the context of the question?
If a company has two directors with 50% share each, for purposes of limited liability, are they shareholders or directors?
I'm not sure I understand the context of that question. I mean, if they're shareholders, they are shareholders. They, as directors, they would each have responsibility for ensuring that there's been no abuse of either furlough or bounce back. I mean, again, it's one of the important provisions in the Finance Act. No knowledge of what your co-director did is not a defence. If you are, you know, we talked about in my first slide with furlough, for example, and the power of HMRC to impose personal liability notice on an individual director. That applies to every director of the company. It doesn't matter whether you delegated the decision making to one director. It doesn't matter whether that one director concealed from his co-directors what happened. Every director is potentially personally liable. And you know, in a small company where there's only two directors, it's even more likely HMRC would pursue both directors jointly for any furlough abuse. I hope that answers the question. The question wasn't quite clear to me, but hopefully that answers it.
Yeah, I think it does. I think it does. It's important to know what your co-directors are doing. Yeah. Nigel says almost. Nigel, do you get in touch with us afterwards? And Ali will be very happy to chat it through with you. We don't have any other questions at the moment, but do continue to post them. I think we're running slightly over time, but we've got another 5 minutes if ever anyone else wants to ask another question. Sean, one question I wanted to ask of you was the question of who's going to fund HMRC to undertake all of these investigations? It seems to me that the sort of likelihood of receiving a letter that you're subject to an audit is going to be almost entirely dictated by whether or not you HMRC have got the personnel and the funding to do it. Has there been anything in the press about that? Or
it's a good question. I suspect they're going to approach it a number of ways. I think firstly, as you quite rightly identified, I think the hotline is going to generate leads. I think HMRC will look at business areas where they suspect more likely to take place, and I think unfortunately that's going to involve business in the restaurant trade and bar trade. I think will be particularly targeted. I also suspect HMRC will adopt an approach that they've been using quite a lot of dispute areas that's being referred to as one-to-many. So what they're doing is they're identifying categories of taxpayers where there's likely to be a failure of some description, and then they're sending batches of letters saying these are the issues that generally arise for companies like you. Perhaps you should consider these and notify us if there's an issue. We've seen it quite a lot in individuals, for individuals, and also some corporates around PAYE benefit issues, and individuals around overseas assets and rental property. So it's something that they quite like. It also raises some interesting questions around disclosure and prompted versus unprompted disclosure for the purposes of penalty abatement, and whether or not after receiving that one-to-many letter you can claim that there was an unprompted disclosure, or whether it's actually a prompted disclosure as a result of receiving the letter. So yeah, they are to some extent dressing this up as being helpful to taxpayers and identifying where errors are likely to occur. But what they've done is they've just identified which market areas there's likely to be issues with, and notifying those issues to them and requesting that the individuals make their own disclosure. That's been happening for the last year and a half now, so I suspect we'll see an echo of that.
And I suspect also it might be defined by success, because, as you say, government wants its coffers refilled, doesn't it? Maybe we can finish on Adam Keats's last question. Adam has asked an interesting question, I think one, Ali, for you, in terms of if you acquire a business that is later deemed to have abused the furlough scheme historically under the old owners, would any director liabilities pass on to the new directors?
That's actually a very good question, and funny enough, it was a question I was asked last week actually by an accountant who's advising directors who are purchasing a business where they know this has happened. The simple answer is no, I don't think it would. It goes back to the point that Sean and I then made, which is it's got to be deliberate by the director himself. So if you as a new director come in with clean hands and say, look, I didn't know about this, I only found out afterwards, then no. In fact, I think what you'll find is the old director will still be on the hook. And I suspect HMRC will still pursue the former director. Because you resign as a director, for example, because you sold the business, that does not excuse you from liability.
Thanks very much, Ali. Great. Well, I think we're slightly over time, but we'll wrap up now and let you all get back to your day. But thank you very much for joining us, and the slides will be circulated to everybody. I think there's also a recording available if any of our accountant friends out there listening want to send it on to clients who may find it of interest. But many thanks. Bye-bye.
Sure.